As we briefly discussed yesterday, I've been following the jury selection in the George Zimmerman case for the killing of Trayvon Martin. We talked about some of the ins and outs and some of the characters that came through as potential jurors. Here to talk more about this and the case is Adam Winkler, professor of constitutional law at the UCLA School of Law, also author of the book Gunfight: The Battle Over the Right to Bear Arms in America. So, Adam, to start kind of broadly and work to the more specific, what is the ideal juror? What are the characteristics of the ideal juror from the point of view of the court?
Well, that can vary depending on the particular case. Generally, one of the misconceptions that many people have about the ideal juror is that they think the ideal juror should be someone who is easily persuaded and gullible. In truth, lawyers often find that the best jurors are educated jurors, people who are smart and knowledgeable, but not too confident and not ones that have prejudged the case. You want someone who's smart because what a lawyer is essentially doing is making an argument, putting pieces together, and wants the juror to be able to put those pieces together and come to the right conclusion. If you're talking about someone who doesn't know how to put those pieces together, it makes the lawyer's job that much more difficult.
Yeah, it seems like finding that middle ground is really maybe the reason for 30 minutes of questions sometimes from the prosecution and then another set of questions from the defense. Because, I spoke yesterday about my experience in jury duty, and it was very clear when we went to deliberate on a self-defense case which did not involve anybody dying that there were half the jurors, in other words, 3 of the 6, did not understand the definition of self-defense that we were to use in deciding the case. So they were smart enough to sit there, they remembered the facts as presented, and they had every intention of making the right decision, but they were using their definition of self-defense rather than the one we were instructed to use by the judge. At the same time, I could see how someone who is overly informed and educated might then have trouble avoiding their own biases potentially.
That's right. You don't want someone who's prejudged the case, and you certainly don't want someone who's a sort of a cocky know-it-all. We know some people like that who are very smart and they think they know all the answers. That's not the type of person you want either, because you don't think you can persuade that person. Interestingly enough, I think that in the Zimmerman case, these high-profile cases like that, the lawyers are not necessarily looking for the ideal jurors. What they're looking to do primarily is get rid of the worst jurors, the jurors who they can't rely on, either ones that are stealth jurors that really just want to be on this case. In fact, in the Zimmerman case, one of the jurors reportedly said outside in the room, "Ooh, I might get onto the Zimmerman case." That might be the kind of juror you don't want on the
Right.
case, because they might be looking out for their own interests and their own aggrandizement rather than applying the law.
It seems like there are. You could imagine why from the outside you might think, hey, the defense probably wants to, if they can hide that there's a juror that kind of thinks their client is not guilty, but it's not so obvious that they could slip them in, that would be something they would want to do. Is that accurate, or could that backfire? Is that not really the thought from defense attorneys?
Well, it might not be a matter of sort of slipping someone in. I think that both sides have probably talked to jury consultants, and figured out what might be some factors that would lead to someone being open-minded to your case, whether it be racial identity, socioeconomic status, or education. Might be a variety of kinds of factors that they might look for. And so they're not looking necessarily to sneak someone on, but they're probably looking to find jurors that the most jurors they can that meet those various demographic requirements. But it wouldn't be a terrible secret. The other side, probably as part of their juror consultants, have thought about what the other side is looking for, and made some efforts to try to eliminate those jurors too.
Who can decide to strike a juror? In other words, must there be unanimous agreement? If the defense alone says that they would like to strike a juror, does that mean that that's the way it goes? Or explain that process a little bit.
Well, jurors can be struck on a number of different grounds. The court can strike a juror. Often, and in most cases, both the defense and the prosecution and the court all agree to strike a juror. But then each side generally does have what are known as preemptory challenges, where they can unilaterally ding a very small number of jurors to keep them off the jury if they think they're not going to be helpful for their case.
Is there any sense for a particularly high profile case like this where every single juror that's come through the jury pool so far that I've seen, there's certainly a range to how much they've heard and how much they know about this case, but everybody knows at least something. How does that change the dynamic of jury selection, and does it favor one side over the other?
Well, it doesn't necessarily favor one side over the other. It just depends on what the lawyer thinks is likely to help his case. One of the issues here is you generally don't want people who've heard a lot about the case, because then they've probably heard facts that might not be helpful to your side. Remember, the trial is generally tightly controlled in terms of what evidence is allowed in, and you want to make sure that jurors haven't heard the wrong information and brought the wrong assumptions into a case. So, for instance, in this case, there's a bunch of jurors who may have heard that the defense was portraying Trayvon Martin in the media as someone who had violent tendencies, who was involved in drugs, stuff that won't be able to be admissible in court. I'm sure the defense wouldn't mind getting some of those people onto the jury, but it's unlikely that they'll get through.
Interesting. And then last question on this is, how can jury selection, or can the selection of jurors be later on in the case a factor, either as a basis for potential appeal, or in what other ways can jury selection be a factor later in the case?
It can be the basis of an appeal if it turns out that there is some kind of bias or prejudice on the part of the juror that was hidden from counsel and hidden from the court. But it's very, very rare. It's the kind of argument that a desperate lawyer makes on appeal without any real prospect of winning.
Let's say, for example, that they don't find a satisfactory jury from this jury pool, what can be done? Can they call for a change of venue and go somewhere else altogether?
It's possible that they could call for a change of venue, or most likely they would just ask more jurors to come in to that particular jurisdiction. It's very burdensome to switch venues. Courts generally don't like to do it. And I don't think they're going to have a tremendously hard time impaneling a jury in this case. Actually, one of the things that's been surprising watching the juror selection so far is that a lot of jurors haven't heard very much about this case, despite the fact that you and I have been talking about it for over a year, and so much of the blogosphere and the media is focused on it. You know, a lot of the jurors haven't seen a lot about the case, so there are not that many concerns, not as many concerns with prejudice as one might have had. I think they're going to pick a juror from this group. Remember, they only have to pick 10 jurors, 6 set jurors and 4 alternates. It's not a large number of jurors in light of the hundreds of people they've brought in for questioning.
No question about it. We've been speaking with Adam Winkler, professor of constitutional law at the UCLA School of Law. Check out his book, Gunfight: The Battle Over the Right to Bear Arms in America. Adam, thanks as always. We're going to keep following the story.
Thank you.